James Daly.
Thank you very much, Madam Deputy Speaker. And I speak in respect of new clause 89 and new clause 97. And having spent 16 years in the criminal courts, I speak with some experience of how cases are proceeded with. My honourable friend is here as Lord Chancellor, and his responsibility is the court system, so his responsibility is the imposition of appropriate sentencing powers for judges to reflect public confidence in the justice system and to reflect the serious nature of offending. And in line with his responsibilities, his department's responsibilities, he has clearly done that. There is an increase in sentences for the most serious sexual offences, which have been outlined by honourable friends already. And he must be commended in respect of this. I share my honourable friend from Burnley's concerns regarding prosecutions, and I know that my honourable friend, having spent a lot of time discussing this on the Justice Select Committee and elsewhere, that a 1.6%, in the last year, Madam Deputy Speaker, 52,000 people reported a rape to the police. Only 1.6% of those led on to a charge or a summons. That is clearly not acceptable. And so when we are debating this section of the legislation, we always have to remember that the justice system can only work if it is linked up with the police, with the court service, with the probation service working together. And perhaps sometimes the disjointed nature of ministerial responsibilities for various parts of the system do not help in terms of conviction rates. But in terms of... Of course.
I thank the honourable gentleman. I wonder if he could answer for me, somebody who worked in this joined-up system or not so joined-up system, why he thinks that in the last 5 years there has been quite such a drop. Does he think that it's not just maybe joined-upness and the lack of it, but a resources issue?
Thank you very much, Madam Deputy Speaker. I'm very glad that the Honourable Lady raised that issue. At the Select Committee on the 15th of June, the Director of Public Prosecutions gave evidence. And his evidence was very clear that his predecessors had failed. His predecessors had not put in place the policies and the actions that were necessary to increase rape prosecutions. And clearly that includes the Leader of the Opposition, who I have to say has an inglorious reputation in terms of the leadership of the Crown Prosecution Service during this period. And I certainly will not accept any lectures from the Labour Party concerning this. No, I will not. And when we go forward, Madam Deputy Speaker, with this, we've heard comments from the other side, but I'm rather curious as to members on the other side stating that they support heavier sentences, they support further action to be taken to protect, which quite rightly is the case, the victims of serious sexual violence. But why in the committee stage of this bill, clause 106, which abolished the automatic halfway point for certain serious violent or sexual offences, did the Labour members vote against that? So we have on record a Leader of the Opposition with a terrible record of leading the CPS. We have a recent vote of the Opposition who are voting against more serious sentences, more deterrent sentences. I've absolutely been amazed by some of the comments from colleagues on the other side of the chamber saying deterrent sentences don't work. The point of this bill and the point of the responsibilities that my honourable friend has is to increase sentences, to increase public confidence in the justice system, and that is exactly what he is doing. No. So I support this bill. I congratulate and thank my honourable friend for bringing forward legislation to ensure that rapists are not released early within their sentences. This is what the public want. This is what we were elected on the manifesto to deliver, and that's what we are doing.